Hi, I'm Tim Takis, one of the partners here at Takis McGinnis Elder Care Law. In many areas of the country, selling living trusts is big business. Living trust salespeople hold seminars at motels, public libraries, community centers, and restaurants in which they tout the benefits of living trusts. These salespeople say that probating an estate, the court-supervised procedure for administering the assets of a deceased person, is expensive and time-consuming and exposes your private affairs to public view. By creating living trusts, they say, people can avoid probate, thereby saving their families time and money in aggravation. Living trusts also avoid conservatorships, they say, because if you become disabled, a trustee is already in place to manage your trust's assets for you. And, especially, you won't have to deal with lawyers and courts. Most of these salespeople are honest. Few will tell you an outright lie, but there are many things that they don't tell you about living trusts. What are they? Here's the baker's dozen. Number 1. For most estates in Tennessee and in many other states, probate is no big deal. It goes quickly, is private for the most part, and does not cost much money. 2. Living trusts can be and are contested, just like a will. The living trust salesperson who claims that a living trust can't be contested does not know the law. 3. Administering a living trust after your death is not cost-free. Even if probate is avoided, the successor trustee should usually seek help from a lawyer in making sure that your debts are paid, all of the necessary tax forms are filed, and the assets in your trust legally distributed to your beneficiaries. Number 4, after your death, your living trust will not cut off the claims of your creditors against the trust corpus. For that reason, the successor trustee will often open a probate estate anyway to require your creditors to file claims within the time required by law or be barred from collecting their claims against your estate. 5, living trusts are much more expensive to set up and maintain than a will. 6. Probate can often be avoided without using a living trust by setting up payable on death accounts, making beneficiary designations, holding assets jointly, and so forth. Number 7. In many instances, the trustor has failed to transfer all of his probate assets to his living trust. Consequently, when the trustor dies, this probate asset becomes subject to probate. His asset winds up in probate court anyway, so the trustor pays twice. First, to set up his living trust intending to avoid probate, and second, after his death, to go to probate court. Number 8, living trusts do not protect your assets from creditors and lawsuits. Number 9, living trusts are no more effective than wills in saving state and federal estate taxes. Number 10, living trusts can adversely affect your eligibility for Medicaid nursing home benefits. Number 11, living trusts are not necessary to manage your property if you become disabled. That's what durable powers of attorney are for, which are much less expensive and easier to use. Number 12, some salespeople sell living trusts so they can learn what assets you own. These people will try to sell you an annuity or other financial product. They are actually selling financial products for a living, not living trust. And number 13, living trusts are not for everyone. Not all living trusts are scams. They are useful and important tools in estate and tax planning when used wisely and considerately. But if someone tries to sell you a living trust and they're pushing hard, it's not a bad idea to be a little skeptical. Beware of the salesperson who tries to sell you financial products in addition to a living trust, and get a second or even third professional opinion on whether a living trust is right for you. If you have questions about trust, Takis McGinnis can help. Just give us a call.